Good afternoon. We would like to welcome you to this second session of the international webinar related to the advisory opinion 3225 from the Inter-American Human Rights Court. The topic for today will be dealing with the analysis of the impact that Latin America has in the recognition of the rights of nature in the context of the climate emergency. In the name of Zenith Plural or Plural, in the name of the Global Alliance for the Rights of Nature, the Observatório of Autônomos Protocols, CEPEDIS, and the Human Rights Program in the Andina University and the Network of Judicial and Critical Research welcome you. This second webinar is framed within 3 sessions that have been programmed. The first one took place last week. This is the second session, and next Wednesday, August 13th, we'll have the third and final session for this cycle of international webinar related to the rights of nature. Today, we are going to have the participation of international presenters that are very important, and we will welcome them and explain briefly their curriculum. First of all, we have the participation of César Rodríguez Garrito. He is the founding director of the MOTH program, More Than Human Life, of the Faculty of Law of the University of New York University. He is a faculty member and a lawyer specialized in human rights, and he's also the director of the Research and Action Clinic for Rights of the Earth. Cesar will expose about rights of more than human beings, and this is a ecocentric perspective of the Inter-American Court. Then we're going to give the word to Maria Fernanda Alvarez. She's a lawyer specialized in human rights. She has 15 years of experience in international and national law. Right now, she's the executive director of CELID PLURAL. She's also a faculty member and lawyer specialized in human rights and public policy. She's had important positions in the Procurement Office, the Ministry of Justice and Defense of Peoples. She will also speak about the advisory opinions emitted by the Inter-American Court and the control of conventionality. In the third moment, we're going to give the word to Gonzalo Ramirez Cleves. He is the editor-in-chief of the magazine Derecho del Estado from the Externado Colombian University. He's also a faculty member and lawyer specialized in international constitutional rights. He's the author of various works and research that focus on constitutional rights and the limits of constitutional reform and the concept of the constituent power. Gonzalo Ramirez will speak to us about the constitutional concepts related to the advisory opinion for the defense of the rights of nature and also the defense of peoples in Latin American countries. We will also have the presence of Liana Amin. She's a human rights professor and coordinator of the Borders and Human Rights of the Universidad Federal de Grande Dorados, and also New Rights, New Subjects. She is a coordinator of the Observatório of Community Protocols, and she will speak to us about different autonomous protocols of peoples and how they safeguard the rights of nature. We cordially welcome our presenters, and we will start with the presentations. In the first moment, we will give the floor to César Ramirez Garrito, who will speak to us about more than human rights, the ecocentric shift of the Inter-American Court. How does the intrinsic value developed by the advisory opinion activism against climate change in Latin America, the strategies that are channeled or are facilitated through this instrument, Before giving him the floor and welcoming Cesar Rodriguez, would like to mention that you can follow us through the different social platforms of the organizations that are part of this event. So we feel it's important to be able to share this with each and one of you. So without further ado, we will give the floor to Cesar Rodriguez Garbito. Welcome. Please go ahead with your presentation. Thank you, Felipe, and thank you to the organizers of CELID PLURAL and all of the other organizations that are working together to bring you this webinar. I'm always working with CELID PLURAL. I always work with Ecuador because I've had, I see Ecuador as a pioneer in the judicial aspects at an international level. And in one way or another, what the Inter-American Court did in their advisory opinion is a movement that Ecuador has led. So I believe that it is appropriate to be in this panel that is organized by Ecuador. As we know that we have limited time, I have 10 minutes, so I'm gonna try to make make a few remarks that deal with the historical trajectory of this recognition of the Inter-American Court of Human Rights about rights of nature. Just to put this into some perspective in terms of what has happened in the jurisprudence level of climate change, because this recognition happened with the advisory opinion about climate change and human rights. And having done this and seeing this historical context, I will focus on what I believe will be the different novelties and consequences of this recognition by the Inter-American Court. In terms of the historical context, I published a book that was also translated to Spanish. It's called Público Siglo XXI, and it's free online. It's called Climate Change in El Banquillo, which is the results of a research that took place during the span of 5 years, and also something that has been longer lived in the legal field and climate change around the world. I first had an experience about this topic in Brazil almost 10 years ago in meetings that took place to a very well-known case. Here's a link to the book that is called The Case of Fundo Clima in Brazil, which condemned or climate policies of the government of Bolsonaro whenever he was given the funds to protect the Amazon. So this is a case that was held by the organizations of civil society, and it was decided by the Supreme Federal Court in 2022. But before 2022, there had been 17 years that had passed with jurisprudence levels that this made that climate change would go to be seen as a topic related to environmental law or environmentalists, and that affected polar bears but not human beings. So for the book, I did a couple of interviews with the lawyers and the different leaders that started with the first cases in around 2005. And the first case was presented before the Inter-American Court of Human Rights and the Inter-American Commission of Human Rights in 2005. And this was an ask that was presented by Inuit leaders of Alaska and Canada against the government of the United States for violating human rights because of the promotion of the fossil fuel companies. This case didn't go anywhere because the Inter-American Court saw it as a rarity or as something that was so out of whack that they disregarded it, saying that it haven't been proved that those who were petitioning this was a matter related to human rights. And this was 20 years ago, and the first argument that was one of the conclusions of the book is that rights or law can change. very quickly. And the lawyers experimented a lot of skepticism from their colleagues and organizations that were even big organizations related to human rights. I considered that this is not a matter of human rights. So I studied with my colleagues and others that have the database of all the um, cases that deal with these matters that are based on human rights that cater to the emergency, climate emergency, in which we have the different compilations that happen in the advisory opinion that was generated in the Inter-American Court. But this is the tip of the iceberg, the arguments, the doctrines, the doctrine about active legitimization, about reparation, about intergenerational equity, the different doctrines about the planetary character, but also the concrete and individual responsibility of each country because of the damages that it causes in each company as well. All of these doctrines were developed along the different cases that are available on the book. I make this very brief summary of what has happened historically in order to land on the advisory opinion, but to show also that there is a, a lot of judicial baggage that can help mobilize the greatest part of these cases. They've happened in Latin America. Many of them have happened. And then right now, law changed. And human rights also changed substantially, much more than what skeptics could have imagined 20 years ago. So human rights have traditionally been more retroactive. So they've dealt with past injustices of which you can find a current remedy. So the current apparatus for human rights have not been meant to deal with consequences that future generations will face and with the passing of time. So nonlinear, the nonlinear timeline of climate change is going to affect these situations. I just want to say that even if this path has been recognized, it's also important to know what is new about the opinion, this advisory opinion. And there's a lot to decide. I don't have much time to do it, but because this is like the contribution about rights of nature specifically. But there's something new and something new that can be shared this way. Until now, there's been an evolution in international rights of domestic law and international law that goes from recognizing a very shy concept of a healthy environment that is related to how it affects beings and human communities. And this is a very anthropocentric conception to a second stage that happened with the advisory opinion of 2017, where the Inter-American Court starts to delve deeper in the possibility that the elements of the environment, as they said in the advisory opinion, are subjects to judicial opinion in itself. So the third step is the one that we are commenting today, where the court decides to shift ecocentrically. What does this mean here? As I am saying this repeatedly, human beings and human rights are seen as part of, that are inserted within the biosphere and the limits that it can support life on Earth before we cause as human beings the sixth extinction or climatic emergency, very serious high levels of pollution. And then if I have time for questions, I would like to point out some of the ideas that are used that are very important in order to note and see the changes that this shift has made, and talks a lot about this planet limits, that speaks about planetary limits that the Earth can support in terms of climate change, energy crisis, and all of the planetary limits that have been led by my colleagues. And the Inter-American Court adopts it very firmly. What does it mean? That human rights are inserted within thought in terms of how much can we share Earth with other life forms or non-human life forms, where all beings can thrive on Earth. And lastly, if you see the language that the Inter-American Court uses in this decision, speaks constantly about the idea of interrelation and interdependence. So what it doesn't it hasn't been difficult for indigenous populations, but for Western people it has been difficult, because whenever we adopted the Universal Human Rights Convention, the main worry didn't deal with planetary limits. It was a protection of human rights, interdependency, and interrelation between what we call nature and what I would call now a more than human Earth, and the works that other eco-philosophers are referring to. They're talking about more than human entities, and that human rights are not separated from nature's rights. So this is the newest thing that I would highlight in order to close my presentation in terms of the opinion of the court. Perfect, ready. Thank you. Thank you, Cesar, for your presentation. At this moment, we will give the word to Maria Fernanda Alvarez, who will speak about the advisory opinions in the Inter-American Court and Control of Conventionality. So we're giving her the floor. Thank you, Felipe. Good evening, everyone. I'm going to try to share my screen. And if the organizers can give me a hand. Can you see my presentation? Perfect. Okay, formally, good evening with everyone. It's a pleasure to be here and share with the presenters with whom I will share this floor. That was a really great introduction to what calls on us today. It's incredible, Cesar, to see how law has evolved, and it's been such a ride in terms of law, so that we're commenting about this advisory opinion emitted by the Inter-American Court. I will give you a brief vision about the topics that I feel are important in this advisory opinion, and I'm going to speak about, as a lawyer, as a lover of interdisciplinary matters, and see how law has to take the hand of other disciplines, which is guaranteeing human rights. And then I'm going to tell you about why I feel that this advisory opinion makes us think about the control of conventionality more than traditionally we have thought about it. And it's focused on judges. And whenever we see the advisory opinion, we will see all of the obligations that are established here that invite us to think that the state as a whole is called upon to respond to this crucial moment, which is climate crisis. What did we ask the Inter-American Court? What are the obligations in the context of emergency, climate emergency? This emergency responds to a triple crisis: climate change, pollution, and the loss of biodiversity. And this is, to me, one of the first virtues of this advisory opinion, because it's a vast exercise of research, of showing up with data, with numbers. It's not an opinion that of the Inter-American Court that we are facing a climate crisis. It's a reality. And what Cesar tells us about this historical path in terms of litigation. So the Inter-American Court analyzes the link between human rights, nature rights, and climate emergency. And of course, one of the main elements about they call on the academic debates is that the Inter-American Court recognizes that nature is a subject of rights. So it goes from that analysis. In one moment, they did this in OC-33, analyzing the right to healthy environment, where they recognize that it's an autonomous right. But in this advisory opinion, it says that rights of nature are a subject of rights. We have to protect nature. We have to guarantee their cycles, the integrity of nature, of ecosystems as a whole. And the human being is part of nature. And this allows me to guarantee human rights as well, so that the Inter-American Court can respond to the question that they're being asked. Of course, part of the array of obligations that states have in terms of rights of human rights, they talk about respective guarantee of progressiveness and not going backwards. So we will find this array of actions and sanctions as well, of course, that the state has to pursue in order to fulfill their international obligations related to human rights in the context of the climatic or climate emergency. That's what we're analyzing at the moment. And so I was letting you know that whenever we analyze the advisory opinion, I like to think that it's a call to think about convention control more than the specific field that we have looked at it, which obviously is the opinions emitted by the judges. Yes, of course, they're important. Well, we're going to see at the end a specific reference that the court does for the judicial decisions and the control of conventionality, but we also have regulations that have to deal with the contents, and they have to adhere to the conventions of the court. And also related to what Cesar was saying, for the protection of human rights. That would come later in terms of what has happened in order to protect what has happened. And the advisory opinion in the context of climate emergency invites us to think about the actions that states have to adopt jointly in terms of the risks that climate emergency states in order to fulfill with also human rights. This is another one of the virtues of this advisory opinion that we are talking about today. Yes, of course, the advisory opinion analyzes the American Convention and the protocol with which the court can pronounce itself, but they also analyze instruments that allow them to interpret these obligations, the framework and the Paris Agreement, but there are also specific actions that determine how the state has to adopt these actions and also abstain from certain actions to fulfill their international obligations. And obviously this integrates in their umbrella and their fundamental basis, which is the American Agreement and the Protocol of San Salvador, that are related to international environmental law and the whole corpus that deals with these matters, and that the court says that nature is a subject of rights. I'm gonna need more time, but just a general panoramic view. There are different rights that are considered. And as I was saying, the court refers to its previous jurisprudence or its previous advisory opinion, which analyzes the right to a healthy environment. But in this sense, the court is very categorical, and it speaks about the rights of nature and the reference to other aspects of jurisprudence, and it refers to the Constitution of Ecuador in 2008, which has been a pioneer of this recognition. So what is the transcendence that the court recognizes the rights of nature? That because of prohibition and the principle of prevention of regression of states in general, countries cannot go backwards on the rights that they have recognized. So here, the recognition of the rights of nature, this is a conquest, and it's consecrated, and it's something that we cannot not recognize, and that if it modifies, the Ecuadorian state will not be fulfilling international obligations that are cited in the Inter-American Court. We cannot go back now. Another topic that I feel is very important in the analysis of the advisory opinion, that is very comprehensive of all the dimensions that are considered in the climate emergency, is how they express themselves in terms of private entities. And even though the state is not considered within this scope, what does the advisory opinion say? It says that the obligations that they remind us of, they have to supervise, control, sanction, and this implies a state structure that should respond to its obligations. It needs to have mechanisms in order to have this control, this regulation. It implies the existence of certain capabilities. So this gives an idea that to fulfill the international obligations in the context of climate emergency is a state as such that is subject to this conventional control. I think, and just to end my presentation in terms of the control of conventionality and legal material, we can check that in the questions. Whenever the Inter-American Court analyzes all of the dimensions that have to respond to this question, analyzes sustainable development, also is part of the obligations of the state. They say what the state has to do. So they say they have to have a strategy for the sustainable development that has to be explicit in international and in national regulations, but also public opinion. And this strategy for sustainable development has to be immediate, even if its implementation is an obligation of progressive nature. And this just to say that the advisory opinion invite us to think that. That's why I'll be done in a second. In order to fulfill international obligations of the state in terms of human rights within the context of climate emergency, they invite us to think about all of the actions from different spheres, but also to think that whomever is obligated to fulfill these obligations is the state itself, at all levels of the government, not only the central government, and all of the functions of the state, not only the judicial aspect. And just to respect time, I end here, and we'll continue if we'll have any space during the Q&A session. Thank you. Thank you, Maria Fernanda. And I want to point out the importance of a set of actions that need to be adopted, taking into account what Jack Cousteau saying, that life itself is in danger. So we require actions from the state. And from this analysis, we were able to see important elements pertaining to this matter. Now we will give the word to Gonzalo Ramirez, so they can tell us about their topics. Good evening, everyone. Thank you for all the organizers that have been putting this event together, and thank you, Agustin Grijalva, for your invitation. The idea that I will propose deals with what happened with constitutionality of countries that are member of the Inter-American Convention, just to try to find if this is compulsory, if this advisory opinion is obligatory or not. And my colleagues have said that the advisory opinions in many countries are part of what is called the constitutionality block. Some of them think that it's obligatory because of the idea of the control of conventionality. But seeing that is a advisory opinion, there's like this soft law that these are not decisions, but is it is this an obligation of what is being stated there? So I feel that there can be sort of a sense of divergence in this topic. So in this famous dialogue between different jurisdictions and the control of conventionality, and it's common to think that this school seeks that the Inter-American School sees a possibility that countries may receive their own jurisprudences and the advisory opinion that might be in one way or another binding. Some of the colleagues have stated what the advisory opinion has said about the rights of nature, and it's consecrated in paragraph 284, 285 of the opinion, and also in number 315, which says in 285, they speak about the tribunal taking notes on 15 resolutions of the United Nations and 3 reports where there is the recognition of personhood of the earth or jurisprudence of the earth and the rights of nature at a global level. And also the United Nations in 2004, they declared the urgent need of a fundamental change in the focus in order to have a world in which humanity lives in harmony with nature. So these are the references that have been used by the Inter-American Court in order to introduce the rights of nature. You have some resolutions of the rights of nature, some reports, and also this future pact adopted by the United Nations as a reference for the future. This is a normative and jurisprudential step at the region and a global level, and it's also a dialogue that has had between the constitutions of Ecuador, Bolivia, but also the decisions that have been made within the region in Ecuador, Colombia. And also they declare that in Colombia that the Rio Trato is the subject of rights. River Trato, they don't name Colombia in the opinion because constitutionally they don't recognize these rights, but they do mention in the jurisprudence that they're referring to. So there are many interpreters that of these different decisions and these normatives of countries, and we could say are Latin America, but they also make a reference to the River Macpi in Quebec, Canada, that recognized them as having rights by the municipality of Miquimani and also the Mecnu of another community that I cannot name properly. And also the United States have recognized the rights of nature, so one can suppose that the Inter-American Court says this is not only that is being produced by countries that recognize the rights of nature because of a vision of their indigenous communities, but in other contexts, we could say that Latin America is not only, and they cite another case as the River Wanganui in New Zealand, but they do allude to this Remember that the notion, and right now I'm going to end my presentation, that starts to happen within this advisory opinions, not only the right to the healthy environment, but a healthy environment, climate. So this is a new thing because this is an emergent right that starts being used by the Inter-American Court. And also in 315, the advisory opinion speaks about rights of nature, a right to a healthy climate, not only pertaining to current generations, but also pertaining to nature in terms of physical and biological sustenance of life. My colleagues have stated that this is a epistemic change going from an anthropocentric view to an ecocentric view based on the fact that nature is not something to be taken advantage of by human beings, but human beings should live in conviviality with nature, not take advantage of it, seeing that it belongs to nature as a whole. And with this idea, this ecocentric view could look like the protection of the climate at a global level should take into account living and non-living components. And I'll leave this here, even though at the end it also says in this same number that the ecological balance needs an integrative jurisprudence focus along with the rights of nature and human rights. The idea is to harmonize this in a framework that is coherent and also with the pro natura principle. I'll leave this here for the following questions. Thank you. Thank you so much. We thank the presentation of Gonzalo Ramirez. And I just want to point out the importance of harmonization of these constitutional principles with the rights of nature. Just to bring a phrase of Vandana Shiva, who says that there can't be a healthy economy in a sick planet. So that's why they play an important role to be able to achieve the protection of nature and at the same time using a constitutional system. And also finishing with the presentations, we're going to give the word to Liliana Min, who will speak to us about the protocols of the peoples as safeguards for the rights of nature. So we're going to give the word to Liana. Thank you. Can you hear me properly? Good evening. Kind greetings to all of our peers who are here and also to the presenters. And also I want to thank CELID for the invitation. I'm going to speak a bit about the protocols as a safeguard for the rights of nature and the experiences from Brazil. Well, we understand the rights of nature. They are inseparable from the collective rights of peoples and communities facing climate crisis or the climate emergency. We also had the experience of presenting an amicus curiae for the hearing of the Inter-American Court that was part of the advisory opinion, which we are delving deeper on. And in this presentation of the amicus curiae about the obligations of the states related to the right to free self-determination of peoples, and with previous informed consultations, we signed many organizations signed in the Observatory for Protocols, CEPEDIS Research Center for socio-environmental research, also many indigenous peoples of Brazil, OPIAC of Colombia, another organization in Peru, Confiniae in Ecuador, among other organizations as well, the Federation of Napo Indigenous Organizations, and also um, Black organizations in Brazil of Quilombola. And after this incident that we did, we also participated at the hearings in Barbados and also in Manaus in Brazil. And our expectation about this opinion, even if we advanced significantly with the recognition of nature as a subject of rights, the context of the climate emergency and all of the importance and the impacts that we have with this new decision of the Inter-American Court for the advancement within Latin America. In the paragraphs 608, the court has established that whenever we talk about development plans and investments, they would have a greater impact within the territories of indigenous or tribal communities. The state doesn't only have the obligation to prior consultation, but they also have to have consent, free and informed consent of affected communities according to their customs and traditions. And the consent, according to the advisory opinion, has to be necessary in terms of actions that show the fundamental importance in terms of the impact within communities in aspects such as well-being, their cultural heritage, or their traditional ways of life, even linked to the exercise of their rights on their land or natural resources. And whenever there's relevant information for the exercise and defense of rights of peoples and tribes, states have to ensure the cultural and linguistic aspects to guarantee their previous free consent and informed consent. And there's a right to consultation and the recognition of the advisory opinion within the jurisprudence that is consecrated and the also the background of the Inter-American Court. And in the advisory opinion adds that the context of climate emergency, other than the consultation, it incentivizes the participation of indigenous and tribal communities and also Afro-descendant communities and fishermen. This is very important to us here in Brazil and also other countries of Latin America because of our struggles and all of the demands that peoples have. We call them peoples and traditional peoples and communities that have their own identity, their own way of life, and they've been linked that are linked to their ancestral territory, to their originary lands and their traditional ways of life. And these are the most vulnerable peoples in terms of the climate crisis. And the court also recognizes this for vulnerable groups that are the ones that are most affected by climate change. And paragraphs 572 also recognizes when the ideas of the CELID committee that affirm that women and female children, defenders of human rights, are facing dangers whenever they promote the rights of Earth and they oppose on the implementation of projects. So the matter of intersectionality of the defenders of territory and the environmental defenders, women and children, indigenous women and children, and traditional peoples are being affected and there's subjects of murders, threats, arbitrary detentions, torture, criminalization, and discrediting of their work. Consent goes from being a fundamental right of the consultation, even if the Inter-American Court doesn't reference the right to free self-determination of peoples. And with that, staying here for the second round of this talk, or the second part of this debate, in order to delve deeper on the roads that peoples have in order to affirm the democracy and the local indigenous knowledge that were recognized by this opinion, such as the right to science, that there's no hierarchy in terms of traditional knowledge. Thank you. We thank Liana for her presentation. Now what we will do is to ask a question to each one of our presenters. Let's remind ourselves that the questions that have been directed to the presenters will be answered in the chat. Right now, we have a question that is meant for Cesar Rodriguez Gravito. It's related to how does the intrinsic value of nature support the advisory opinion and activism against climate change in Latin America? What strategies are channeled or are facilitated by it? I don't know if Cesar is listening to us. Yes, perfect. The intrinsic value of nature talks about three elements or refers to three elements. Some of them are new, others that have been talked about in litigations and laws within the region. The first one has to do with the integrative vision of the rights of nature when it's applied to activism against climate change. What do I mean by this? Up until this point, there was a tendency to treat work and judicial activism about climate change as if it were different from the work done in terms of biodiversity laws, biodiversity in general. Sorry, not laws. And these three climate emergencies, they treated them as if they were different compartments. And the disadvantages of the success of climate litigation, such as in the reflections that we make, has tended to become a sort of specialty and a preoccupation that you're linked to the defense of life on Earth in terms of biodiversity and fighting against air and water pollution. And one of the advantages of the intrinsic value of nature is that it sets as a precedent that all of these emergencies are deeply intertwined. So litigating or deciding on a case or developing a public policy, they can protect a species or an ecosystem or a river or a forest or some sort of animal species or plant or mushroom. Yeah, that this subject to be protected is synthesized in terms of the struggles related to climate change, in terms of biodiversity. And this is well known to you in Ecuador and also internationally, which is the judgment of the Los Cedros case. And I've visited that site and I keep following it and studying it in terms of judicial aspects and its ecological protection, and also the integrative value of something of the decisions such as Los Cedros, which is the protection of an endemic life in this forest, and the function that it has in order to provide clean water to the surrounding communities, and also the value it has in terms of that a forest like Los Cerros has for climate change, because by definition, it's a mechanism to absorb carbon and other greenhouse gases. So these three currents that might be seen as separate have the advantage of being integrated through the defense of the rights of nature. And what I expect to finish is, or what I would expect, is that decisions, the judges, the courts, the litigators will be much more aware of integrating the differences and the different considerations in their doctrines, their strategies. And I think this can be redundant in the benefit for the defense of rights of nature and human rights, and also a bigger attention to all of the ecological crisis and not just one in particular. Thank you, Cesar. Now let's go with the following question, which is addressed to Maria Fernanda Alvarez. Is the advisory opinion to be fulfilled in an obligatory manner? In what way do social organizations, judges, and public authorities can use it to promote the rights of nature and a right to a healthy environment? Thank you, Felipe. I think that the obligatory fulfillment of the advisory opinions, that even though from international public law or the classic perspective, is different from what you have in a contentious case. So this would not be judicially binding from the jurisprudence and the work that the Inter-American Court has done. It's been explained that what happens is that advisory opinion is the official interpretation of the organization that can undertake these aspects at an international level, and tells the states how they can fulfill these consecrated obligations in the convention, which is a binding treaty ratified by the states. And in this advisory opinion, what the Inter-American Court does in this specific case tells the states how they have to fulfill their obligations. And the consequence is that if states don't adapt to the guidelines that the Inter-American Court has established, whenever there is a contentious state case, they will be responsible. So what happens? The advisory opinion doesn't resolve specific cases of a specific case in terms of a specific state, but the Inter-American Court tells you how you have to fulfill your obligations. And in this advisory opinion specifically, in paragraph 560, the court is very clear in terms of talking about the control of conventionality, and it says, whenever litigations are in judicial matters that might be presented within the framework of climate emergency, the authorities must effect the necessary actions in its jurisprudence in general, but the court says in particular related to this advisory opinion. So they're being very straightforward. It tells the authorities, government officials, that whatever I say in this advisory opinion, or whenever you have to solve issues, you have to consider what I told you in terms of this advisory opinion. And this is a little bit of what is related to the next question, and then what way do you use this as a tool? So yes, I was telling you that this is a very extensive advisory opinion. It talks about an array of topics because the phenomena and the context that is being analyzed, it's very complex. The court says it from the start. And it says that this is a planetary crisis. It doesn't affect just the state, it affects the whole planet. It affects humanity as a whole. So here's where we will find different instructions that the court gives the state. And the tool is there. Now we need to appropriate ourselves of this opinion, dissect it. What are the standards that are being established? And we can also apply, I feel, in terms of what I was saying, they can be applied in the litigations that, of course, it's fundamental and there are standards that are established by the court in this advisory opinion in terms of the proactione principle, collective tests as well, reasonable deadlines where these situations have to be solved. These are very important matters in terms of a healthy environment and the rights of nature and human rights. And what Cecil was mentioning specifically, but there are many spaces where there is a tool in order to generate advocacy, to ask all of the levels of the state to adapt to all of the parameters that are stated here. One of the things that the advisory opinion says, and it remits to the obligations that are stated in the Convention about Climate Change and the Paris Agreement, deals with information. And they talk to us about the right to the generation of scientific knowledge and also the respect and integration of ancestral knowledge. So you have an array, as Ali was saying, of different actions that have to be adopted by the state. And I think it's precisely because you are integrating international obligations that were assumed within the framework of climate change, not only in terms of your own jurisdiction, but also among states. You have a huge amount of spaces in which you can apply this as a tool in order to defend rights. And also in terms of finalizing, what I was saying is that I think that the advisory opinion is an opportunity and a tool in order to think about guaranteeing rights at every level, not only in terms of the judicial aspects that, of course, are necessary, but that are facing all of the damages and also the importance of avoiding environmental damages, is thinking how the state has to do its planning, it has to generate its own public policy, it has to rethink what it is doing now and at a long term because we are facing a crisis of planetary dimensions. It's not only about getting a law out or emitting a law, it's about the state with all of its planning tools and all of the dimensions that it has in terms of particular actors, in terms of bilateral agreements and thinking about the rights of nature, rights to a healthy environment, and all of this integrated within the framework of guaranteeing human rights. Thank you, Maria Fernanda. I want to remind you that you can follow us on our different social platforms of CELID PLURAL and the Global Alliance for the Rights of Nature that have been shared on the chat during this session. I also want to remind you that this event has had the participation of the human rights of the University Simón Bolívar, and also remind you about all of the programs that are being offered in the Universidad Andina or the Andina University, specializing in human rights and also supporting tools for these times of crisis. So we recommend that you can check this out. You can find the information within the chat about these academic programs that we feel are very important. Now we will follow up with a third question that is, directed to Gonzalo Ramirez. It says, from the constitutional point of view, what does this advisory opinion imply for the defense of nature and human rights in Latin American countries? Thank you. This is a very important question, and we talked about it a little bit during the first part. Each country has within its own constitution a series of regulations that are related to what could be called the different international treaties and what it was called the constitutionality block, which is the Article 93, and also Argentina and other contexts such as the Ecuadorian one, in Peru. They have given way to what could be this idea that finally treaties and human rights and their decisions, even the advisory opinions, are binding. And the control of conventionality and others that depend on this principle that guarantee the sovereignty of the countries, you could say, and what internal law might be. But it's also really important to focus on the international treaties and the conventions and the agreements, and also the decisions made within the countries at a constitutional level. There are countries that have more have developed more within their constitutions. The case of Colombia, Bolivia, Ecuador, Bolivia, Colombia recognizes the right to a healthy environment, and other constitutions that could sketch out protection, environmental protection through the constitutional way or jurisprudential way as well. But it doesn't say that it doesn't, if it doesn't have a norm that protects the environment, it doesn't mean that they shouldn't link it and that they can change this paradigm. So, in my opinion, even if you don't have a constitutional norm that recognizes the rights of nature, this opinion speaks firmly about the rights of Mother Earth are the rights that start to be recognized and have to be recognized internally, and that jurisprudence and the constitution of each country can start taking into account mainly related to of a healthy environment and a healthy climate, which is something new in this advisory opinion. I think that in Latin America and the members of the Inter-American Commission that are binded to this advisory opinion are a paradigm so that their decisions, their courts, their tribunals can look at what this ecocentric shift is doing. Not only because they might not have a specific norm that establishes rights of nature, you can't say that there weren't budgets that were made at a international level that can establish this transformation. So I feel that we have to focus on how this opinion or this binding opinion should be internally for each country at a constitutional level. Thank you, Gonzalo Ramirez. Now we will go with the last question that is for Ileana. Liana, what are what is the advisory opinion doing in terms of the strengthening of citizen participation for the defense of nature and human rights? How can these defenders of nature take advantage and give life to these contributions? So we see the context of this climate emergency. The court has established that interdependency between democracy, state, and rights and the protection of human rights is the basis of all of the system of the convention that it is part of. And the convention between the state of law, it has acquired an important relevance in the climate impacts such as food security, economic impacts, migration, and meteorological events, and also in terms of shortages or scarcity. So the public participation and the access to justice in environmental matters, we have the Escazú Agreement and the right to have more information on the context of climate emergency. So the court recommends to states that are called upon in order to empower through environmental education the strengthening of the capacities of the people that are part of civil society for good environmental and state governance. And it was facilitated through different it has to be habilitated through different channels for communication, and also promoting mechanisms to integrate the interests of nature and future generations in their climate action. The court emphasizes on the framework of the environmental impact studies and the importance of free, prior, informed consultation. And I would also like to highlight that this is a point that the court refers to in terms of the report to the right to free self-determination. And the advisory opinion has emphasized the right to free self-determination, but it took as a basis the report of the of indigenous and tribal peoples of 2021. They refer to it. And this report for us in the Observatory of Community Protocols is very important because the Inter-American Commission recognizes the importance of autonomous protocols that are tools in the exercise of free self-determination, and that is related to the experiences of the protocols that are practical and the recognition of different practices of the different indigenous jurisdictions of traditional peoples, so that diversity of peoples reflect the different judicial systems and also the social organizations. Now, what we are learning with Carlos Mares, who has also emitted opinions in terms of this, through the transmission of knowledge in future generations, recreates norms that regulate life in society. In Brazil, the experience of Protocolos Autônomos shows us how there is a possible path that signify the demand and the way that the state needs to implement the free prior consultation and the agreement of the ILO and the different self-determination of peoples and the United Nations. And the Observatory of Community Protocols has registered the compilation of these cases, 150 judicial and political documents written up by its own peoples from Brazil and other countries in Latin America. The protocols emerge because of the protection of physical and cultural rights and in good faith. And as they have in common the fight to be, to exist, the fight to respect the freedom to live their own ethnic identity. And I would also say that it highlights the right to veto that the court didn't recognize even during its last judgments of the case UBA of Colombia. They don't recognize the right to veto, but for us who are also reflecting alongside the teachings of indigenous communities, that we can't talk about consent if we can't even say no, that we can decide not to consent, that there are mega projects that affect peoples, and at the same point, they also contribute to climate change and all the natural disasters that we are facing, even in the energy transition and lithium mining, the aeolic parks. And I'm speaking right now from Bahia because I am in the event of the anthropology meeting of Mercosur, and aeolic energy affects traditional peoples who live in the coastline. So how this different protocols have affected the electric plants of Belosan or Belomonchi, and now the Belosan, the autonomous protocols of the indigenous peoples that they seek to have to revindicate the freedom of their peoples. Whenever they claim for self-determination, and the processes for consultation and collective decisions that affect their lives and their territories. We learned valuable lessons about ancestral jurisdiction. I'm really sorry, she's reading and I cannot keep up. They spoke about the Atrato River as a victim of the armed conflict and the contamination of illegal mining. In Brazil, there is a movement to recognize the rights of nature as a subject of rights, and they presented an amendment to the Constitution to give dignity to non-human beings. Even if the rights are many, because of the composition of the National Congress that we have here, especially after the government of Bolsonaro. So in conclusion, the rights of nature are inseparable from the collective rights of peoples and communities that are fronting the emergency crisis, and these strategies and praxis from the autonomous protocols as a safeguard of the rights of nature and the custodians of the territory. They highlight the right to consent and effectiveness in terms of participation, democracy, and the right to consent and free self-determination of peoples. Thank you. Thank you, Liana, because we are so doing well with the time, seeing that they've been very respectful. We will give the opportunity to answer live some of the questions that were asked in the chat box. So in this sense, because we'll have just this last section, please take no more than 2 minutes to be able to, for the presenters to answer the questions. We're going to follow the same order. For Cesar Rodriguez, the question says, whenever we're talking about the shift to biocentrism, we see life as the center of it. Nevertheless, we still keep referring to human rights as if nature is subordinate to what humans consider rights. Seeing that living beings should recognize themselves in a natural order as a basis for the normative human hierarchy, for them to adapt to natural law over human law, many times contrary to this natural cycle, what would be the difference in practice if it's more of a subject in the human order? And the decision of the court and other courts and other legislations around the world consist in affirming the interrelationship and the radical interdependence between human rights and more than human rights, as I like to call them, and also how many movements have called it, and also experts have called it in the movements of rights of nature. What is important to highlight is that an ecological holistic vision of the planet implies that human beings recognize at last and other as other indigenous peoples have recognized and other Western traditions have recognized that human beings insert themselves in the web of life, as Humboldt says, that feeds human life, that human life depends on, and that human life contributes, saying that human rights, and this is what I affirm in the book that was mentioned, or that is that human rights are a sort of a wider genre, which are the rights of the more than human world, of the earthlings who inhabit this earth. And in one way or another, that even though this will not solve any conflicts, we can think about a holistic view, and conflicts, it's worth mentioning, are not new. We're working in constitutional law and human rights. We're used to ponder these concepts. So in order to introduce these the rights of non-human subjects, rivers, forests, mushrooms, what it does is introduce other variables in this exercise of ponderation, but it's not that they're going to start, these rights are going to start to search because rights of nature are being recognized. Thank you. Now we're going to go to present the question to Maria Fernanda Alvarez related to how do we explain the authorization of mining of Quimsacocha. I think seeing that there was a public consultation. Yes, precisely. This is one of the context of the advisory opinion, but also the jurisprudence of the Constitutional Court should serve as instruments or as tools to stop it, because the analysis that should be done is really interesting in terms of the debate. And I speak specifically of Ecuador that is being presented in this dichotomy or rivalry between what development means or the defense of rights of nature. So in this sense, the advisory opinion is interesting whenever it says sustainable development is an obligation of states, the right to development. And it speaks about the instruments to the right to development. So whenever we think about these projects that don't fulfill these standards, inter-American standards, in light of what is being established in this opinion, but in the corpus of Latin American level in general, the obligations have to have environmental impact and guaranteeing that the activities, and this is really important because the opinion that we are analyzing is not an ideal. It doesn't say that there shouldn't be any contamination being produced, that the human activities in general are not going to impact the right to a healthy environment. What it says is that states have an obligation to guarantee that these human activities generate very little impact, and then you have a series of guarantees, and then the Ecuadorian case, there is a catalog of guarantees that must be fulfilled. And so within those are respecting all of the obligations that you have to fulfill before authorizing a project, but also everything that you have in Ecuador in terms of what citizen participation means. In the cases where you say we don't want mining activity in this area precisely because of the environmental impact that it will have in water, free, in the healthy environment and human rights. And here, in terms of, yes, you're always going to have to ponder these rights, but more than pondering rights in this case, I believe that it is a term of public discourse. It's a debate that tries to put in juxtaposition the rights of nature and a healthy environment versus the right to communities to develop themselves, economic, social, cultural rights of communities, because you say that you, with these activities, you'll be able to guarantee these rights. And this is a fallacy. And I think that we can prove this in Latin America. Precisely the authorization of these projects in the way that they have been authorized. I don't want to go very far from the advisory opinion. I don't want to leave this jurisprudence of the Inter-American Court, but to the dispositions of the Constitution of Ecuador and the normative that guarantee that the entrepreneurial activity that needs to be executed doesn't have a disproportionate impact to the right of to water, to a healthy environment, and also the judgments of the Constitutional Court, and also the exercises of citizen participation that the advisory opinion recognizes as part of these procedural rights. These are very important exercises for citizen participation that say, we don't want mining activity for this and this and this reason. So if you want to establish a clear example. Sorry, I can't hear. Thank you so much, Maria Fernanda. Now we're gonna go with a question for Gustavo. It says in Ecuador, the rights of nature rights of nature are recognized as an object of protection of jurisdictional guarantees in the advisory opinion in paragraphs 279 to 285 also recognizes nature as subjects of rights. Is it possible for a cause to protect and repair rights of nature will reach the knowledge of the Inter-American Court after very damaging acts made by the state? My colleagues have mentioned this already, and it's that the advisory opinions are the commission and the court. Think about a specific case. Can develop the ideas that happen there in terms of the right to a healthy environment and how the rights of nature. I think these are two elements that bring us this advisory opinion. So we'll have to see what the case is. In our region, we have different circumstances that can give way to a contentious case in different countries, such as Ecuador, Colombia, any Latin American country, Bolivia, Mexico, what have you. We can, case in Brazil can happen that somebody says, we're thinking that this related to what could happen with climate change and climate emergency. And the idea of protecting healthy environment, healthy climate. There's a case that we're gonna take to the court or the commission as well, to the advisory opinion, other than the judgment, or judgment 123 from 2024, a specific case that spoke about climate migration. So it could happen that a certain country or a certain place or certain people can take a case forward to the court, and the court decides to use this advisory opinion with this new ecocentric shift and the idea of to have a healthy climate. They pondered this and the reparations that need to be made. And I feel that these could be ecological reparations that have been working on. So the principles of prevention, precaution, and other types of mechanisms. We need to reestablish any environmental damages that might have been produced through the rights of nature. It could be understood in a very different way, and also seeking alternative solutions to what has been stated by the Inter-American Court. Thank you, Gonzalo. Sorry for the change of your name. I'm sorry I changed your name. In any case, I want to thank the whole team that is supporting us so that this can come out the best way possible. Finally, a question for Liana. Angelina Valenzuela asks, now that the Inter-American Court has pronounced itself about the intersectionality of the double characteristic of being a woman and a defender, what do you think are the implications to the state or the challenges? Greetings from the University of Monterey. Thank you, Felipe, and thank you, Angelina from Mexico, for your important question. We know the challenges that we have between Mexico and Brazil, and we have in common the sad reality of the violence of femicides in Brazil and Mexico. We are unfortunately in this ranking of feminicide. And in Brazil, the data about the Indigenous Missionary Council of the reports that civil society has for the from the organizations of environmental defense, they show us that the defenders of human rights that are murdered are the defenders of the territories. They are indigenous peoples, the quilombolas, the Black communities, peasant communities that are in the front lines against capital, against capitalistic interests. I see that there's a Daniel Quirola question. So how do you explain mining exploitation under the popular referendum? And the same thing happens in Brazil, and these matters are related. Women who are murdered, like Bernadette from Bahia, who was a Babalorisha, who was very important, Quilombola in her own territory. She was listed in the program for defenders that need to be protected, but we had the government of Bolsonaro and the government of Lula started the reconstruction of the national program for protection of earth defenders and human rights defenders under the people who have been protected by these programs keep being murdered. And I worked in the university that is in the south of the state of Mato Grosso and the border with Paraguay. And here we have the Guarani Karawa peoples, and we have many cases. Unfortunately, 2 years ago, there was a case of the massacre of Vapo in the territory that we call the Guarani Kiowa territory, and all of the violence against women leaders, old women leaders, the violence of the police and armed groups, military armed groups, as well as in Mexico and Brazil, and unfortunately our countries of Aviala. And all of these peoples are the defenders and the intersectionality aspects of it that are intergenerational, young people, and how this different scenarios of violence intimidate young people in order to follow on their ancestors and elders' footsteps and what they taught them about the defense of the territory. So this is a challenge that is huge for our states as well. And I believe that we have to strengthen these programs to protect the environmental defenders with the Escazú Agreement and Agreement 169, and the opportunity to have consultation and the intercultural dialogue to understand the territorial defense under their cosmovisions and their social organization, traditional social organizations. And I think that we have a lot to learn from peoples and also to walk for this critical interculturality to understand the dimension of nature as a subject of rights under our own cosmovisions and the vision that we have as Latin America. Thank you. I want to thank the presenters. To bring this webinar to you, and I want to remind you that for next week, we have our third encounter. You are cordially invited in order to join us next week. And in this case, we can close this session in the name of all the organizations that have taken part in this event. Thank you so much. Have a wonderful night to each one of you in the different parts of the world that you're joining into this call. So thank you so much. Thank you.